The invitation. My name is Gary Gerling. I'm a lifetime long resident of Evansville, Indiana. I graduated from Bosse High School in 1955 from the University of Evansville. In the class of '59, I actually got my degree a semester or so later in 1960. Enrolled in IU Law School at Bloomington in the fall of that year and graduated in 1963. Things were different in those days and times. It was very easy for me to get into law school. In fact, I had originally planned to go because I was married. I already had a child, and my wife was expecting a second child at that time. It looked like it was out of the question. I went to the Indiana National Guard camp that summer, as we were all required to do, or volunteer for the draft post-Korean War. And in my 10-man tent in that school was Wayne Kent, who had just graduated from Notre Dame, Reese O'Connor, who was enrolled to go to Indiana, John Burke, who had just finished his first year at Indiana, and me. So 4 of the 10 people in our infantry tent were either in law school or thinking about it. I had worked my way through college, thought I couldn't do that and go to law school. Those fellows encouraged me, and I thought, well, if they can go to school, I can go to school. And I came home, picked up my transcript from the University of Evansville, went and visited with the dean's office that morning, and handed him my transcript, and he said, "Mr. Gerling, we'll be happy to admit you into our law school class." And I was one of about 167 new students in the first year of law school in the fall of 1963. At the time, there was no housing left available, so I drove down the street and found a trailer court, got the Evansville Morris plan and to loan me $3,500, and bought a trailer and moved my family into the trailer and started into law school. Fortunately, while I was there, I continued to sell home improvements as I had done for the previous 5 years. I sold them in and around Bloomington instead of in and around the Evansville area, and used the proceeds of that to pay for my most of my education. Oh, stop. It was nice that the university gave me a scholarship during the second year and during the third year, which helped defray my costs and expenses. Out of our 167 students in our class or so, we graduated 67. At that time, easy to get in, hard to get through. In fact, in the early days, the professor would tell you on the first day in class, look to your left, look to your right. 2 of you won't be here next year. Which one will be back? And most of those that got through this system not only got through the system, but it gave us a unique kind of self-confidence that we were able to perform, I think, without worrying about whether or not we were approved by others. And I think that's a key trait that a lawyer must have in order to be in the general practice law especially, is the willingness to break ground, move along, make decisions, do things that whether they are or are not approved or accepted by others. And in fact, in our law school class, as I recall, we brought back to Evansville, Reese O'Connor became judge, Ed Wallace, who was at Bamberger, Foreman, Oswald, and Hod, Rod Grove, Malcolm Montgomery, who was an early public defender and did defense work, Ralph Moore, and I sure hope I didn't leave anybody out, but all of us were somewhat reluctant to return to Evansville because if we got here, there would be 150 lawyers in the county. And we knew the county of Vandenberg could not support 150 lawyers. But we came anyway and thought we would carve out our own spot. Now I understand there's maybe 550 or 600 lawyers, and the complaint's still the same. Many lawyers tell me the county cannot support the number of lawyers that are in the county today. That part hasn't changed. Because when I graduated, while I was there, I was busy. I had delivered the second child and a third. So when I got back to Evansville, it was pretty hard for me to take a job with anyone since I was earning more selling home improvements than what the starting salaries were. In fact, I was earning several times as much a year as a home improvement salesman as the $6,000 a year average starting salary for lawyers in the Evansville area. That left me no options except open my own office, which I did. First in the court building for about 5 months, and then out at the brand new facility in the east side of Evansville, Washington Square. And I had a small office downstairs there. I thought I was high tech because I was capable of typing on an electric typewriter and using a recording machine, and I had a copy machine. And I did my own typing, and I used to say and joke that for the first 5 or 10 years I could never afford a secretary that could type as fast as I could. So I did my own work like that. And I'd say the interesting anecdote for me is when I got to Evansville and started I was invited to the first Bar Association meeting. Prior to the meeting, several lawyers called on me to welcome me to the Bar Association and presented me with the Bar Association's handbook. The purpose of that was to call my attention to the fee schedule that was contained in the handbook. It listed the minimum fees that you would be permitted to charge as a lawyer. It was explained to me that if I charged less than the minimum fee schedule, then it would be deemed a solicitation and would be unethical. That meant I was a new lawyer, and all the old lawyers were charging the minimum fee schedule as their maximum fee. So the client had a choice. They could hire the oldest, most experienced, and best-known lawyer in town on a divorce case, or they could hire me. You can understand that it was difficult for a young lawyer to get much business under those circumstances. A couple of years after that, the Federal Trade Commission got after all the bar associations, and then, of course, as we all know, the minimum fee schedule for price fixing by lawyers is no longer permitted and is watched carefully by federal agencies. I suppose that my early stage, I had to start someplace, and I looked into trying to get a job as a deputy prosecutor. I found out the deputy prosecutor's pay was at the time maybe $3,500 or $4,000 a year. I felt like if I visited the Evansville City Court from time to time and got hired on occasion, I could probably create more income just being around there than I could be as a deputy prosecutor. So I elected to put on a three-piece suit, carry a briefcase. Since we couldn't advertise, my name and title, attorney at law, was prominently displayed on my new black briefcase. I found that if I were in the courtroom, and since I was acquainted with Judge Kent from National Guard time, he would occasionally appoint me as a public defender to represent people. From there, I was able to garner a minimal kind of practice in that area. I got involved in political activity. I remember I had a case, a small case with Judge Miller, who was then the Vanderburgh County Attorney, and Bill Miller was also Secretary of the Vanderburgh County Central Committee, Democrat Central Committee, and active in political activity. At those days, Frank McDonald Sr. was running the city, and who served as our mayor for 16 years. His team included Joe O'Day, who eventually became the county clerk, Beulah Evans, the wife of the president or the vice president of SIGCARP, Bill Miller, and Louis Yacarino was treasurer. In that case with Bill Miller, we had a disagreement, and he suggested to me that I would need to agree with his way of resolving this case. Otherwise, I would not do well in my goal to be politically active in the Democrat Party. My language wasn't good, and I said things to him I probably should not have said at the time. But after I cussed him out real good and did nothing, it looked like we had a bad relationship. But about a year later, he called on me, came to see me, and told me he thought that he was standing in line to be appointed as a circuit court judge to take Ollie Reeves' place. If anyone ever had a chance to practice before Ollie Reeves, it was quite an experience. If you filed a motion for change of venue from the judge, he then found a way to punish you over and over and over again. being a young lawyer in the first few months, not knowing that, when Howard Sandusky, whom I originally shared some office space with, sent me to court as a favor to him to file a change of venue in one of his cases. And Judge Reeves jumped on my case and wanted to know when I got there, where I came from, and told me, young lawyer, you've got a lot to learn about this courtroom. Of course, he had to grant the change of venue, and that meant Judge Ollie Reeves and I had a bad relationship from that time on. But Judge Reeves went on, Bill Miller took his job, and Bill Miller offered me the opportunity to take over his practice. He wanted me to close my little practice down and take his, and in the event he lost the election, give it back to him. And I said, no, I can't do that, but what I will do is this: I'll run yours and mine at the same time. If you win the election, we won't have any problem. Then I can combine them. He was elected. He had to stand for office in 18 months. He was elected overwhelmingly, and that meant I had his practice and my practice. I wanted to keep mine. Malcolm Montgomery, my classmate, was the public defender, and I said, here, Malcolm, you take Miller's office in this practice, and I'm having to pay the rent and the secretary anyway. So I'll pay all of it for you for 6 months. That way you can get in and get started on your own practice. Malcolm took that up, moved, and as a result, that was his first step into private practice on his own, and he remained in that private practice the rest of his career. And we lost him early, but he did very well. So our classmates, we all kind of stuck around. We tried to help out each other. And I'm proud to say that everyone that graduated in our class has had I think a highly successful professional career. My practice then, I always said we graduated from one area to the next. I got into criminal law in a bigger way, and was fortunate to handle a couple of first-degree murder cases and burglary cases and serious criminal cases. I would say the highlight of my young and early career was defending Dotson Simpson in state of Indiana versus Simpson, a case in which Dot was alleged, well, he had gone to a motel on Highway 41, followed his wife there. She was there with a daytime rendezvous with an employee from the Vectron, or SIGCARP at the time. And they were there in the motel room. The wife that was there called the motel clerk and told him that they were afraid to come outside because Dot was outside waiting on them, and he had threatened to kill this man. And so the police came out, and 2 squad cars came, 2 police officers from went and talked to Dot, and Dot said he was just there to get evidence because he was going to sue her for a divorce. So 2 of the officers went into the motel room and found the man cowered in the shower, afraid to come out, and told him if they would come on out, that they were 2 officers, they would escort him to his car safely. And they told Dot that, you know, we're going to stand here beside of you, and this man's going to leave. So when the man got into the doorway with 2 officers on either side of him and 2 officers on either side of Dot, Dot pulled out a small Derringer, and who was an excellent marksman, shot him once in the heart, or once in the belly, and as he bent over, shot him a second time in the heart, killed him instantly, and was charged with first-degree murder. Dot was a friend of mine, or acquaintance of mine from high school, and he knew I was practicing law, and the testimony was he announced to the police officer who was reading him his Miranda rights that he didn't need that, he just wanted to call his friend Gary Gerling. That case was tried for a couple of weeks. We tried it on the basis of temporary insanity. The judge found, the jury found Dot not guilty by reason of temporary insanity. And Judge Morris Merrill, whom I'll always remember for this gesture, had listened to all the testimony and agreed with us that he was only insane at the time of the commission of the act. He was perfectly sane at the conclusion of the trial, so he ordered him released immediately rather than being sent to a mental institution. I don't think that would happen under today's rules of evidence and law and the procedures, but I would say that that case and the publicity attendant to it gave me a boost up on my career from that point forward, and I'll always be grateful to Dotson for calling me. I'm sorry Dotson committed the act, but from a lawyer's standpoint, it was a dream, because we were taught in law school by Jerome Hall, who wrote the book on insanity and had the textbook in law school, that the true test of temporary insanity is whether or not the defendant would commit the act with a policeman at his elbow. We had a great case here because we had 2 policemen, one at each elbow, and everyone and every psychiatrist and everyone that testified agreed that that was an appropriate test for insanity, so it made it a case that you really could use the textbooks and the doctor's opinions there, and it was it was fun at the time and worked out well for me. I'm reminded that over the years that we had no disciplinary commission. So lawyers pretty well disciplined themselves. We had a small number of lawyers, very little interference from the Supreme Court, state of Indiana, and what have you. That's all changed. We had no advertising in those days. Advertising was not permitted, as I mentioned before. So lawyers found clever little ways to advertise. In fact, Judge Lensing's father, who had been judge, had a law office out on Weinbach Avenue, and he had a sign that was larger than just the normal sign of Wendell Lensing, attorney at law. It was a larger sign, could be easily visible from the street. And a matter came up and requiring him to write a letter to the Supreme Court about something, or when the disciplinary commission first started. And he wrote a letter, and they all agreed that he was certainly not guilty of any kind of an offense, but his attention was called to his sign, and he would need to remove his sign because it violated their rules. It was tantamount to advertising to have a sign that was larger than a standard sign. I would say the most successful lawyers in the community when I started practicing law, at least appeared to me, were Wilbur Dassel, who had all of the union business, Fred Bamberger, who put together the Bamberger, Foreman, Oswald, and Hahn firm, now these names escape me, Bill Fitzgerald, who did the railroad work, had Wesley Byers joined. It was just an interesting group of people that we all policed ourselves and seemed to have very few problems about accusations of rule violations or unethical conduct. Lawyers seemed to be helpful with each other. Very few, I don't recall anyone ever being sued. Very few cases against doctors. Usually we were reluctant to take any kind of a case against a doctor who then expect him to testify on behalf of other clients later on in accident cases and such. So I would say in general the lawyers got along very well together. In the old courthouse across the street from where I'm speaking now, there was the probate court and the circuit court when I began, and we just had started the first a superior court. Shortly thereafter, we got to Superior Court number 2 with Terry Deach becoming the judge. And many people don't know this. Terry's father was had been sheriff, and he was active in Democrat politics. Most all of the judicial appointments had some political connection originally. But all of these persons that were selected and appointed went on to practice without regard to their political affiliation and had distinguished careers. Friday morning was a zoo. in that all divorce cases were pretty well handled in what was called the probate court at that time. It had a civil court division. Morris Merrill was the judge. There were no ante rooms, there were no conference rooms, there was no place to have any kind of privacy. And the way we did is we put our clients between the stacks in the law library, which was adjacent to the courtroom. So when you were trying to work out a pendente lite, or the temporary court order at the first hearing, you would have people would be all over this library whispering in various corners and talking loudly. That's when I first met Marion Rice. And Marion Rice, interesting story, and probably others have told this, but Marion Rice is one of the last lawyers who did not actually go to law school. He graduated with honors very highly at Central High and worked in a law office and was elected Evansville city judge at age 21, the youngest city judge in the history of the state. He was very articulate, he was very bright, and a very good lawyer. And of course, he was one wild guy. As Steve Martin would say, he was a wild and crazy guy, and well known for drinking and partying and etc. And was very demanding and very intimidating and would push everybody around. The first time I had a case with him in the probate court in that division, he jumped all over me, and I looked at him and I said, well, Mr. Rice, I'm just sorry that you would speak to me that way. One of the reasons I went to law school was my admiration for you and what you've done in the practice of law. At which time Mr. Rice turned to his client and said, we better listen to Mr. Gerling. He's got the right idea on this case. Let's agree to that. And from that time on, he and I had a wonderful relationship because I gave him the respect and dignity that he demanded and expected and that he very much deserved. I suppose Bob Hahn, I would have a lot of admiration for. He was a great lawyer, great defense lawyer, taught me a lot, especially the very first personal injury case I had, in which my client's complaint was that due to injuries received in the accident, she was unable to control her urge to urinate. And during the course of the trial, every 15 or 20 or 30 minutes, she would stand up, leave the room, go to the bathroom, and come back. However, as Bob Hahn aptly presented to the jury, the medical evidence did not really support her activity. And of course, we lost that case, and we learned to get better prepared next time with better evidence if we were going to be doing business with Mr. Hahn. Then, of course, over the years, we were able to reach many good settlements and good arrangements with his law firm. I admire their firm. They were good lawyers and people that you could rely on and depend on. Let's see. It might be interesting. Let's take a break a minute, okay?
Yeah, that's fine. You're doing great, Gary.
In response to Susan Helfrich's question about when did I start being something other than the general practitioner, I suppose the prelude to that was that I was strictly a general practitioner until 1968. I was a Vanderburgh County attorney for a couple of years, and during that time I became well acquainted with Winfield Denton, who was our congressman. Winfield ran for Congress that year. He had a disagreement with the Downtown Central Committee and Mayor McDonald. And so rather than using the Democrat headquarters down on 4th Street, he used my law office, which at that time was across the street from the courthouse in a little building that's over here at the corner of 4th and Court. He lost that election. So following that election, he asked me if he could join with us, and we made an agreement. And we changed the name of the firm to Denton, Gerling, Grove, and Moore, which included Rod Grove and Ralph Moore, two of my classmates from school. And Winfield was the, quote, lead partner, but he was retired at that time. And he really didn't do much. He wasn't interested in doing very much work. He was just interested in keeping up his relationships and having an office. So he took me to a meeting of the Teamsters. And at that time, the Teamsters were were having a disagreement with the city, and the Teamsters were trying to organize the sanitation workers. And at that meeting, I was there, and Winfield spoke, and Winfield told the group there that under the law they could not strike. Well, Cliff Arden, who was president of the union, almost came out of his shoes because he'd been telling them that they could. So the following week, Cliff came to see me, and we kind of transferred the account from Winfield to me because I agreed with Cliff they ought to be able to strike. I thought they'd be able to strike because the judge would be unwilling to issue an injunction. We struck. The Teamsters struck. A lawsuit was filed by the city against the Teamsters. I forgot who the judge was that came up in front of at the time, but he was a politically astute judge. In those years, they ran for office, and he did not issue the injunction. He was unwilling to issue the injunction. He bought our story that because of recent modifications in labor law that public employees now could strike. However, we knew that the case would be appealed by the city. Net result of all that was that we entered into negotiations with the city of Evansville and the sanitation workers. This is a story people may or may not remember. The Board of Public Works, in an order to embarrass the Teamsters, insisted that all the negotiations be made public, which I thought was a good idea. Consequently, I called the then fledgling television stations in town and invited them to participate. So as a result, for the next several days, for a week or so, while the garbage sat on the street, the Board of Public Works sat at a table with them on one side, Cliff Arden and me and another union official on the other side, and we, quote, negotiated a union contract on television. That is the first step of union recognition by the city of Evansville, and since that time, as you know, the Teamsters have gone from representing those people, the city employees, the school corporation employees, and a great number of public employees in the city, and have seemed to have had a pretty good relationship with the Democrat administrations and the Republican administrations. I had the good fortune in those years from '68 until 1977 of being attorney for the Teamsters, which took the place of Wilbur Dassel had died, and I succeeded into his role as a union lawyer. Part of that, then, I resulted that I represented all the employees at 808, the local 808 at Whirlpool. Did some of the work for the iron workers, the carpenters, the plumbers and steam fitters, and all the printing trades council. It gave us, we represented unions that had probably 20,000+ employees represented, and that all of a sudden became a big part of my work. And so having a practice each year of trying to get rid of whatever took the most time and produce the least amount of revenue, we would get rid of things. I did at the bottom end. So we got rid of collections, and eventually we got rid of divorce work, and we got rid of certain things. So at that time, my career pretty much was representing the Teamsters and doing administrative practice. I represented the developers in the area. I rezoned the property for Washington Square. I mean, not for Washington, for the mall. Eastland Mall, and the stuff on the west side, and the stuff up and down Green River Road. And I found myself going to all zoning meetings, either the council or the commissioners, either on one side or the other. I was either opposed to it or I was in favor of it. But we did a lot of administrative practice, a lot of zoning work, a lot of union work, and began to do some high-profile criminal work and high-profile divorce work. And then so that was our practice. In 1977, the Supreme Court decided the case of Bates versus the state of Arizona versus Bates, in which they declared that legal advertising was appropriate. It was a time in my life when I had some personal issues going on, and our practice was such that we were certainly spending 70 or 80 hours a week between the unions and domestic relations and criminal cases and administrative practice and some smaller business corporate things around town. It was just about could drive a person nutty. So I seized on that opportunity and announced to my partners that I decided that I would go solo. I was going to start my own practice. I was going to limit it. I was going to resign from the Teamsters. I would resign from the unions and limit my practice to personal injury. My good friend James Lopp, Sr., who was always a good buddy and always welcomed me into the Bar Association, and whom I interviewed with as a senior in law school. And he didn't hire me because I smoked. And I don't blame him, because when I quit smoking, I didn't want anybody that smoked either. And he, in essence, told me, if you'll quit smoking, I'll give you a job. Well, I wanted to smoke. So he had a small office, and he didn't allow any smoking in his office. But we always had a good relationship. Hit a stop button. That put my train of thought someplace else. So I called Peter Dooley. Pete Dooley, if people may or may not remember around town, he was a musician. He was an advertising guy. He was a television station manager. He had a wide array of experiences, and he was a fraternity brother from the University of Evansville in my class of 1959. And I said, Pete, I want to do a little advertising. What can we do on a very small amount of money? So he came down and we met, and he said he would set me up. I would have to pay him $75 a month for his advice, plus the cost of the advertising. And at that time, we were fearful. We thought we could advertise, but we thought we could not do it on radio or television. We could only do it on the newspaper. So I put a small ad in the paper around a plaque that said, my practice was limited to personal injury, wrongful death, and related insurance claims. And the telephone began to ring almost immediately. So with that information and the telephone ringing and learning that eventually we could advertise on radio, I resigned the practice and limited my practice to personal injury. The case was decided in '77, and I made that choice in 1978. James Lopp came to me as my friend and said, Gary, I've got to warn you, that's the biggest mistake I've ever heard of a lawyer making in the Evansville area. There's not enough of that kind of business to keep a lawyer busy. You'll have to do other things. And I said, well, Jim, I think maybe everybody's misread the market. What's happening is there's a lot of people here that are having accidents. They're not being represented because they're fearful of the unknown. They're fearful they cannot afford it. And when we tell them that it doesn't cost them anything to see us, we'll get more cases. And of course, that's turned out to be true. Now, at the time, everybody knows that. But at the time, it was really a strange thought that was different than all the lawyers. All the lawyers thought that the way you got a law practice going was to do a good job. In fact, they were willing to take a case and work on it for nothing in order to get a reputation for being a good lawyer to get hired later on. They had no idea that you could advertise. My concern was I had a great practice, it seemed, a growing practice. We had position and standing in the community, but it seemed obvious to me, from having been a salesman through law school and such, and having a business-oriented background, it seemed obvious to me that unless I jumped on the advertising bandwagon, a new young lawyer would come to town whose father would have funds and resources, would advertise, and would be able to take from the practicing lawyers their business in a matter of 60, 90, or 180 days. It seemed to me that you had to advertise to protect your turf. Otherwise, you'd be out of business. And I think that's turned out, fortunately for me, to have been true. Bob Simpkins started advertising at about the same time. Bob took a plunge, even though the Supreme Court had a specific rule prohibiting advertising on television. He signed up with a group out of Colorado, Denver, that did his advertising, and they agreed that if he were charged with any offense or bothered by the Supreme Court, they would provide his defense. They did. They took him to the Supreme Court took him to federal court over here, and it was resolved, and the resolution was we all agreed you could advertise on television. And from that time forward, it's only been a matter of truth in advertising and advertising with reference to the rules. The advertising changed my practice, changed my life, and fortunately we were correct in assessing the market and the potential. What happened before, it seemed like maybe only 10 or 15% of people that had an accident went to a lawyer. They only went to a lawyer as a last gap, desperate attempt to get something after they had been manipulated, maneuvered, or they thought mistreated or abused by the insurance company. That was their thoughts. I'm not assessing that about whether the insurance companies did or did not do something inappropriate. That small number of people ended up that they hired a lawyer they knew, and it would be someone with whom they'd had some contact with. So you would end up with a number of lawyers like me, like Mr. Lopp, like Marion Rice, like Ted Lockyer, the lawyers on the plaintiff's side of the case. We would all have in the course of a year maybe 5 or 10 accident or injury cases to go along with our other work. Advertising changed the whole picture. Within 3 years of the time that I had begun advertising, I had to add lawyers, and we were at a time, and for a number of years, we had pending at all times 500 to 600 accident and injury cases that we had to process, giving each lawyer sometimes as many as 130 or 40 cases at one time to work on. Computers helped us, other things helped us, and we were able to process those cases by setting out that during the first 30 or 60 days we assembled information. The next 30 or 60 or 90 days we attempted to negotiate settlements, and we ended up that if a lawyer had all these cases, he would actually only have 10, 15, or 20 in litigation at any one time, so he could manage and handle those. We found that was too many. We would cut it back. Eventually, we would get rules that you could only handle a certain number of cases, and then we would add another lawyer to handle those cases. Now I note that it's gone completely the other way. Now we have so many lawyers advertising that the caseload is again diluted. An interesting note to this, that from a business standpoint, when I first began practicing and advertising, I set a budget based upon 5% of my expected gross income to be my advertising cost. I reached that because in advertising circles it was well known that the companies that were major advertisers would only spend 5% of their gross profit on advertising, 3 to 5%. They reached that number, and out of that, the rest of their profit, then they paid their overhead, rent, employees, and et cetera. Their gross profit did not include, their gross profit included a cost of goods sold. Well, in the law office, we had no inventory. We had no real cost of goods sold. So I felt like good business practice would be that we would spend 5% of our gross income on advertising, community activity, and public relations, and we did. But in the early years, since the business would grow each year, at the end of the year, we would actually only spend 2.5% or 3% because we would have a huge increase in the amount of business. Now, over the years, that began to change, and by the time I retired and turned the practice over to my daughter in 1999, that year that we began making that transition, advertising kept increasing as a percentage of cost. And lawyers then and today seem to justify that extra expense on the basis that if they're relied on cases being brought to them by another lawyer, they would have to pay a referral fee and share with the other lawyer. And the referral fee traditionally has been if the lawyer did a very little amount of work but had a relationship with the client, then the referring lawyer would take somewhere between 25% and 33 1/3% of the fee. And if he worked in it and they actually worked together and worked full time and each contributed the same amount of effort to the case, they would divide the fee. I think that, I guess, and I'm not there anymore, but it would look to me like with the number of lawyers advertising the available work, the lawyers have got themselves in a pickle here now where they're spending a huge percentage of their gross income on advertising, trying to get the better cases. And that it's diluted to such an extent that the better cases are only going to come from personal relationships developed with clients. I think my group, we had a window of time that was unique and unusual in which many lawyers wouldn't advertise, refused to it, fought it. The court adopted rules to interfere with it, to make it stringent, to make you fearful, to make you that you would be afraid to do it for fear they might do something to you. That's all changed, and now I note that all of the law firms in town advertise in some way or other. Even those that clearly say they do not are busy sponsoring newscasts on public television. They've got brochures, they mail it out to their clients. So the advertising and public relations has become a part of all the practice. It's gratifying to me to some extent. It does. I did feel like it is an affirmation of what I predicted in the Evansville area in 1977, and it has come all the way around. And I said then, this will be this way for a long time, and then eventually it'll go back the way it was, and that is the better lawyers will get the better cases. That's always been true. The better lawyers, those that have a reputation for getting a good outcome, good relationship with clients, pay attention to their business, they do better. And I think that'll happen all the way through. Answer your question?
Do you think that's where we are now, that attorneys are back to selecting a lawyer is based on accomplishment and knowledge in the community and being well known in the community, rather than just the amount of advertising, the back pages of Yellow Pages and that sort of thing?
The problem with Yellow Page advertising is that they never run out of paper. So you can't buy all the space. You can't buy all the time. You cannot dominate the media. And they just keep adding pages. So dollars spent on Yellow Page advertising, studies would show today, people do it because they're afraid to quit. But the dollars spent on it are certainly not indicative of what the outcome of results should be. It's not, in my judgment, it's not a good place to spend your advertising dollars anymore. I think what's happened is this, that we're to this extent. We're probably getting where we ought to be. Good companies, good law firms, who are good companies, must make an effort to have a positive image of their organization, and they must let the public know what they're doing. One of the major problems of people thinking badly of lawyers is we have no group that speaks for us. Lawyers are independent, and we handle our outcome, but we don't put a spin on it. We sue McDonald's, we win the case, we get the victory, and the evidence is overwhelmingly in favor of the burn victim. The burn victim who was not driving a car, who was driving down the road, who was served coffee that was sitting in her lap and spilt and received severe burn injuries to her private areas of her body. And the evidence was clear that hundreds of people suffered these injuries, and McDonald's still didn't reduce the temperature of the coffee. But after the case, and after McDonald's put its spin on the case, it looked like the lawyers had done something really terrible, and that the law was really bad because it had permitted someone to recover because they just didn't take care of their coffee. Knowing that's true, and that the other side is organized, they have public relations, they have personnel that do that, the law firm must go ahead and do it itself. And I think that's where we are today, that a good law firm should have its a public relations arm and its advertising arm. But for good business practices, they have to keep the cost of that reduced. And one of the ways to reduce that cost is to advertise to your constituents, to your local people. The more you reach out and try to advertise and draw in the best cases from other areas, the more difficult it is to tell your story to the local people. I think what you'll find is that the better lawyers will survive in this, and that they'll do well, and that the better law firms will, as they're doing now, will have a good advertising and public relations campaign, and they'll have somebody, what we do is newsworthy. And in years past, that people don't realize, the newspaper always had a policy here of not printing the name of the lawyer in the case, in a civil case. That was their idea, that they would not give the lawyer free advertising because his name would then be in the paper. So they would talk about the attorney for the victim or the attorney for Mr. So-and-so and not identify them. That began to change, and one of the ways to change is you've got to put out a news release, because if you put out the news release, the television stations and the newspapers in the area are starved for news, and they'll print out all the news. So those are all areas that are perfectly legal, perfectly lawful, and should be utilized by law firms just like they're utilized by any other business. People like to get their story out. And law firms need to be supportive of community activities, and I think that's all important. I think that for the Evansville area, we clearly were out front and pioneered the idea of advertising, because I started with a budget of $200 or $300 a month. And by the time I quit, I had a budget of hundreds of thousands of dollars a year, and each year it just went up, and now I think it's shrinking and needs to shrink and needs to come down. So that's my story of how I went from a general practitioner, a lawyer who was involved in politics, general practice, and representing labor unions, to a lawyer in 1963 to 1977 for 14 years, to a lawyer in 2009 that is limited its practice and specializing in accident, injury, medical malpractice, and product liability. Another area that's changed a great deal over the years in practice law. There was no real product liability claims or suits in 1963 when we got out of law school. In fact, we were always taught in law school, McPherson versus Buick. You couldn't, the guy McPherson bought the Buick, and brakes were bad. He had the accident, and he couldn't recover from Buick because he couldn't prove that they were negligent when they built the vehicle. And he could only recover from whoever he bought the car from, and they didn't have anything to do with building it. So the courts and Ted Lockyer took a case to the Supreme Court with the X-frame and had an X-frame on the Oldsmobile, and got product liability recognized. It's changed over the years, and it's a big area. The pendulum swung from nothing for the consumer to everything for the consumer, and modifications have been made in that law now. It's back more in the center. But these are all areas that have changed dramatically over the period of years. Domestic relations, you couldn't get, when I started practicing law, you had to allege for a divorce wrongdoing by one of the parties. Adultery or cruel and inhuman treatment, and you had to offer testimony to support that. No fault came in, and for years, number of years, once no fault came in, the courts took the position that it's just a 50-50, you're just two partners, it's a 50-50 divisor. And you had a period of time from 1977 up through the mid-80s in which women who were spouses at home received very little support or help because the courts thought that the legislature meant that You get married, you bring what you got, you get divorced, divide it in half, you go on about your business, regardless of whether you're capable of taking care of yourself or not. That's all changed. These pendulums over the years, they swing back and forth and back and forth. We always go too far in one direction, and we take it back in the other direction.
I always end with this question. If you could listen to one oral history from all the attorneys you've worked with, have you got one that you'd really want to listen to, that you'd want to hear from? You could take it from humor, you can take it from talent.
Well, I would say John Klaus.
John Klaus.
Yeah, John was a lot of fun through the years. We always had a good time together. We had, his sister was a teacher to my kids at Harper Grade School, and I always thought I had a special relationship with John. He always he used his money to travel and have a good time, and I guess I liked Jim for the same reason that Marion Rice liked me. John always told me good things about myself, and that's the way to have a good friendship and relationship. He never missed an opportunity to compliment my practice, our business, and what's going on in life. A lot of things changed during the years. When I first started practicing law, in the city, we had city court down at Third and Locust in the city building. We would have the trials scheduled usually on Friday night. And the routine we would make is you would swing by city court, hit that court at 8 a.m. You would go to the other courts at 8:30. We got the court things out of the way early in the morning. You were back in your office at 11 to see people. The idea that a jury trial should start at 8 in the morning and go to 5 o'clock in the day to get it over with was fought. And old lawyers never did that, and judges didn't. We thought unfortunately, there was always another case. And if you've got this case over, then you just had to start another one. You could not do your general practice and do all the things you needed to do and be in the courtroom from 8 o'clock in the morning to 5 o'clock in the afternoon. So we'd have those cases on Friday night. Well, before we'd have the trials on Friday night, you had to dispose of the early pleas and the people paying their fines and what have you. So we would all gather at F's. And we would sit over there and eat some Cantonese food, and we would drink alcohol. And then we would go to the courthouse, and we would probably, they were somewhat simple cases, but boy, we were exuberant, and we would make noise and what have you, and that was Klaus and Bates and John Hancock, and I would say on oral history, I'd like to have heard Claude Bates's, very interesting person. So we did those things, and then I guess something I didn't mention, which was kind of a highlight, was interesting. I was county attorney whenever the city and the county got together and elected to issue bonds and to build the city-county building. So that was an interesting experience. I was county attorney when we built the Vandenberg County Auditorium. I think about those numbers back then. I think at the time we were doing the city-county building, the school carp and all that, we were talking about spending $10 million. And we could get bonds for 4 or 5%. And we had the same complaints you have today with the new arena. People in the public would write letters and complain, say the city couldn't afford it, it was too expensive, we'd never be able to pay for it. Frank McDonald had a lot of foresight. He saw that, and he insisted, and I was attorney for it, and as a lawyer, I agreed with it, and I worked for it. But as a kid from the south side of Evansville, and poor, I thought, boy, what a waste of money. I really didn't agree. I did not have the foresight at that time to realize that. And we moved the city, county, all that stuff out of the police station, and we called it the police station. That's where it was. Police station was on one side, and city court was there, and on the other side of the street was the city building, and the city offices were located there. So all that's changed. And one of the best things we've ever done in this community is build the city-county building and that complex down there. And it's served the community well, and it's turned out to be very inexpensive. In fact, the original rents ended up way more than they needed, and they've done things with the money over the years and rented that, and it's been a financial boon to the community. Also, they saved, we saved the courthouse then. The original plan was, let's tear the courthouse down. I was county attorney. The county commissioners at the time were Dick Hewitt, who owned Hoosier Abstract, Charlie Elsperman, who was with Citizens Realty and Insurance, what's the painting company here? Gosh. Gilhausen, Roman Gilhausen. Those are the three commissioners. And they voted to save the courthouse. Of course, the courthouse is still here because of some of those decisions. So it's been an interesting time. How much time have I used up here?
About an hour.
Oh, okay.
You've done a great job. Is there anything you want to add, Gary? You want to talk about how does it feel to leave to be turning your practice over to your daughter?
Oh,
that's interesting.
Yeah.
Were there any women in your law school class?
Yeah, that is it. Yeah, and when that's interesting. In law school, we had one woman in my class, and I think 2 or 3 women in the class behind me. Women practicing law was pretty much unheard of. And there are issues involved in the way men approach problem solving and the way women approach problem solving, and then you put those two approaches in the same office on a case together, there's some disagreement. So I've had when I hired women, I did hire over the years. I did hire a few women in the law office. The first one I hired was an interesting note or experience. She came to work, and one night I heard her on the telephone giving a really hard time to whoever's on the other end. And in fact, foul language and telling them off and everything else. It was just awful. And I said, who in the world are you? I walked by there, and she hung up, and I said, who in the world were you talking to? She said, that was my father. And I thought, ooh, well, I don't think it's because she was a female she had such a bad temper. She was just a person that had a bad temper. And later on, something came up, and she came into my office and began to treat me the same way. And I just said, oh, hold it. I'm not your dad. I'm your employer. You can't do that here. But I say my early experiences were not good. The later experiences with female lawyers were very good. And then when I decided that I was going to retire fairly early, my daughter was practicing law in Indianapolis. She had been with Baker and Daniels, which that's an interesting story. I was Baker and Daniels Indianapolis law firm. I was the first summer associate that they ever hired.
Oh.
In the summer of 1962, they hired me, and the only reason they hired me, the senior partner that was really in charge of hiring wanted to hire his own son from Michigan, and he didn't want it to look like it was this family-oriented thing, so they just took 2. They took one from Michigan and one from Indiana, and I got the job from Indiana. And then my daughter went to work for them. She married Mark Pettinga, has the financial services here in town, and she took a job with Baker and Daniels because they wanted to be in Indianapolis. So then she left. She got involved with doing the Prozac litigation at Baker and Daniels for Lilly, and then Lilly hired her away from Baker and Daniels to be a case manager. And then she had a daughter, and then she was pregnant with another daughter and was flying from Indianapolis to California, taking depositions and doing work on the Prozac litigation with the Church of Scientology as in a lawsuit that they filed against Lilly. And I said, gosh, that sounds like a terrible way to live. Why don't you come back to Evansville? And so she came back to Evansville. Mark left his company and came and started a new business down here. And I did it with the idea that eventually she could take it over. So in '99, although I was 62 at the time, I thought I was burned out and tired. And she and I entered into an agreement that allowed her to take it over a 4-year period of time, from the time I was 62 to 66. And now I'm 72. So it doesn't seem like that long, but 10 years has passed rather quickly. And yeah, it is somewhat exciting. Gail has tried to approach the business more on the public relations and different kind of advertising and building a firm image than the direct advertising that I did, which I think is a necessary change. And of course, I am very proud of her, and I'm proud of the law firm, and I'm proud it's still there, and it's kind of fun to still have your name there. But it is when you quit or change, it's change, and I admire the lawyers who like it well enough they just want to stay forever. But I learned early. I think I learned early. Time for advertising, and then that two people can't run a business, and I don't believe a parent can fairly run a business with his child in the business, because they're always your child. It's always your kid. Everybody says they wouldn't be there without you, and etc. So if you're going to do your child a favor, this is my opinion, putting them in your business, then you got to do the real favor. You got to put yourself out of your business in order to put them in your business. As you can probably see, I'm a person, I've never worked for anybody my whole life, and I follow my instincts. And my instinct was to take off at 62, and do something different, and it's been rewarding, it's been fun, and it's fun to watch them, and I hope they have continued success over there.
That's great.
Okay.
Thank you very much, Gary. Excellent.
Thank you for inviting me.